deemed to have delivered the unit, and the purchaser shall be deemed to have accepted the unit upon the earlier in any of the following dates, Your Honor. And there are three. The date of final inspection, or if the purchaser fails to inspect the unit within 15 calendar days from receipt of the final notice of inspection. Letter B, the date of possession by the purchaser of the unit. Letter C, the date of execution by the purchaser of the acceptance form. And letter D, and this is where we are relying, Your Honor, is the date of execution of the deed of absolute sale. So when the deed of absolute sale was executed, Your Honor, the prosecution is of the position that delivery was made. And in the case that I cited, Your Honor, a while ago in Marcella versus Court of Appeals, Supreme Court said that it is of no legal consequence that petitioner did not take actual possession or occupation of the disputed property after the execution of the deed of sale in her favor, because she was already able to perfect and complete her ownership of and title over the subject property. So that is the prosecution's position, Your Honor, that upon execution of the deed of absolute sale, possession was transferred, and according to the Supreme Court, Your Honor, in Marcella versus Court of Appeals, it was of no legal consequence that the petitioner did not take actual possession. And that is our position also in this case, Your Honor.
Your Honor, just very briefly, if I may. I filed a memorandum on February 15th regarding the transfer of ownership, and we cited precisely Cebu Winland, where the Supreme Court held that symbolic delivery by the execution of a public instrument can be negated by the failure of the vendee to take actual possession. Now, good counsel has cited the execution of the absolute deed of sale, and that would have been sometime in 2004. It was, however, at that time, Your Honor, impossible to take actual possession because, as pointed out by Senator Osmeña yesterday, they were just buying space. The condominium did not yet exist, Your Honor. It came into existence in 2006, which is the only point in time, realistically, that any intelligent acceptance of the goods can be made.
Well, gentlemen, you of course realize that the filing of the SAN is governed by the implementing rules and regulations of the Civil Service Commission. Have any of you gentlemen taken the trouble to inquire from the CSC when should ownership be transferred or deemed to have been transferred with respect to a condominium unit?
I'm afraid, Your Honor, that our inquiry into the matter is inconclusive. I am guided, however, by your statements yesterday that we should first have been motivated by honesty. As pointed out by Senator Lacson, the Chief Justice honestly declared this condominium unit in 2010 as testified by Mr. Lim after it was accepted in 2009 by Mrs. Corona. And Mr. Lim further testified that the acceptance was information given to him by the builder or the seller. So we consider that as an admission on the part of the condominium builder or seller that the transfer, the complete transfer of ownership and the free, intelligent, and voluntary acceptance of possession occurred on August 12, 2009, regardless of the provisions on deemed acceptance and the issuance of title in 2004.
Your Honor, for the part of the prosecution, our inquiry with the Civil Service Commission, they informed us, Your Honor, that the SALN form itself, as well as the provision of the Constitution, the Anti-Graft and Corrupt Practices Act, as well as Republic Act 6713, clearly states that whenever an asset, Your Honor, is acquired, it must be stated. And as duly noted by the presiding officer yesterday, Your Honor, when payments were made in 2003 and in 2004 for this particular unit, an asset should have been declared by the respondent, Your Honor, because asset it has an accepted meaning, Your Honor, and no quibbling on the meaning of asset should be debated upon, Your Honor. An asset, when you take out the cash from your pocket, then you get an asset. And this is what we are trying to point out. Acceptance of the unit, Your Honor, is of no moment because in 2003 as well as in 2004, an asset was acquired by the respondent already.
Your Honor, just very briefly, supposing the condominium had never come to be, would that 3-point-something million still be an asset? It would have become a liability.
It is, Your Honor.
If that condominium unit never came to existence and no delivery was had, it could not possibly have become an asset.
Not a liability, it would be a receivable.
Receivable.
Mr. President,
Well,
Mr. President,
Yes,
Gentlemen, may I still...
the gentleman from Cebu,
may I
the
have,
floor.
no, I was just going to
Oh,
ask
I
the
thought it
permission.
was the
with
lawyer's
the
talk.
permission of the
I
gentle
can
lady
cede the
from
floor to Senator
Iloilo.
Osmeña.
Thank you, Madam Senator. I think the Senate President has a better understanding than most of us do of the concept of assets and liability. An asset can be cash, it can be a receivable, it can be a property. And as far as we're concerned, we don't really care if the condominium existed or not. It had to be booked in 2003 and 2004 as an asset, and if the unit had not been delivered, it should have been booked maybe as a accounts receivable from Ayala Land. If the unit was never delivered, even in 2010, that 3.5 million should still have appeared in his asset side. Otherwise, we have a David Copperfield thing. Now you see it, now you don't. Obviously, there was 3.5 million taken out of the asset side of the SALN of Justice Corona and given and paid to Ayala Land. So ano po nangyari doon? Hindi naman nag-appear in 2003, 2004, 2005, 2006. Then all of a sudden, it appears as a condominium in 2010. The condominium is irrelevant. The value must appear. That's what we're saying. Thank you, Mr. President.
Mr. President, I stand corrected. If the condominium had not appeared, that is right. It would still be a receivable. That is right.
One more question for the prosecutor and then I am done. Mr. Prosecutor, are you familiar with the word tradition in the law of sales?
Yes, Your Honor.
What does it mean?
Your Honor, tradition means that there are other forms of delivery rather than other than actual delivery of the property, Your Honor.
Are you sure that is the meaning of tradition?
That is as my recollection would serve me, Your Honor.
Maybe you need some multivitamins for neurons in your brain because that is not the meaning of tradition. Tradition comes from the Latin word which means to, like for example, to translate. That is a relative of the word tradition, meaning to say, to convey, to give manually. That is quoted by Manresa, who is the favorite basis of all our civil code writers. And Manresa insists that tradition is part of the transfer of ownership. That is what he says. He is, of course, the father of the civil code, at least as known in our country. And according to him, ownership does not pass by mere stipulation, but only by tradition. He says, the delivery of a thing signifies that title has been passed from the seller to the buyer. So my question to you is, has there been tradition in the sense used by Manresa and our other civil code authors like Tolentino, etc.?
Yes, Your Honor. We believe so, Your Honor. By execution of the deed of absolute sale, Your Honor.
All right. I'm very satisfied with the answers of both counsel. Thank you, Mr. President.
Thank you, Your Honor.
Counsel,
Senator Drilon, Mr. President.
gentleman from Iloilo.
Yeah, just a few questions on the witness, Mr. President. Mr. Lim, did I hear you correctly in response to the questions of Senator Defensor Santiago that the only time when you charge association dues is when there is acceptance?
Yes, Your Honor.
All right. And therefore, acceptance has nothing to do with the date when the deed of sale was signed.
Yes, Your Honor.
It has nothing to, acceptance has nothing to do when the date, with the actual date of registration of the deed of sale was done.
Yes, Your Honor.
In fact, acceptance has nothing to do when, by law, the ownership was transferred. Is that correct?
Yes, Your Honor.
Now, in fact, payment of union dues can be delayed. The payment of condominium dues can be delayed by the simple refusal of the owner to accept the unit. It can be delayed.
There is a possibility, Your Honor.
Yes, there is a possibility. And in fact, in this particular, in your position, you have no access as to when the titles were issued,
Yes, Your Honor.
nor when the titles were registered.
Yes, Your Honor.
That's all for the witness, Your Honor.
Actually, I think we are all confused about this whole thing, but actually it's simple as far as this chair is concerned. We are talking of asset. The asset originally was how much? 3-point-something million. That was transformed into a concrete asset known as condominium. But still, from the beginning of time of this contractual relationship, there was an asset. Only that it passes from cash to a concrete thing known as a condo unit. The condo unit came into existence when it was actually constructed. But all along, there was an asset that must be reflected in one's SAL-N, whether it is in the form of a condo with a number placed opposite it, or a currency account with a number placed alongside with it. Isn't it? The consideration for the condo was an asset that ought to be reflected in the SAL-N of the buyer. So, whether we talk of pesos and centavos or unit, there was an asset from the very beginning. Okay?
We agree, Your Honor.
All right. Counsel, next.
Yeah, Your Honor, may we request that Mr. Lim be discharged?
The